everyone. Thank you for joining us. No, it's early. Possibly been out at the Law Society pub crawl. Let's begin. We're going to start off with a brief introduction involving the distinction between civil and criminal wrongs. Civil and criminal. The distinction between the two is essentially one of procedure. Now, a wrong is civil if it can be followed up by a civil procedure in a civil court. A civil court. A wrong is criminal, however, if it can be followed by a criminal procedure. Yes? Are you with me? Are you with me? Sometimes a wrong may lead to both civil and criminal proceedings. Both civil and criminal. Important differences that you must note, and you must understand these, between the civil and criminal proceedings. In civil procedure, the person wronged raises the action. He raises the action himself. Contrast this with criminal procedure. This is raised by the procurator fiscal. It's not up to the person if they want to raise the action. Now, each type of procedure has its own distinct vocabulary. Civil speaks of the pursuer, the defender, damages, interdict, specific element. Now, contrast criminal procedure. And bear in mind that in English civil procedure, the parties are the claimant, or prior to 99, the plaintiff and defendant. Now, I have seen many a time these basic vocabulary mixed up between criminal and civil vocabulary. Don't do that in the exam. Just don't do it. Alright? Don't do it. The police tend not to be involved in civil procedure. These proceedings are initiated in courts possessing civil jurisdiction. Civil jurisdiction, do you think? In civil courts. I'm going to talk about the composition, jurisdiction, and appellate procedures in Scottish civil courts. At the top of the hierarchy of the civil courts have the European Court of Human Rights, the European Court of Justice. Below this, the Supreme Court of the United Kingdom, which replaced the Appellate Committee of the House of Lords. Appellate Committee of the House of Lords in 2009. Remember that, we'll come back to that. Below this, Supreme Court, previously the House of Lords, which will be referred to hereafter as the House of Lords in lectures, often, is the Court of Session, divided into the inner house and the outer house. Now, the inner house has a first and a second division, both of equal authority. Now, below this, the Sheriff Principal, and further down yet, the Sheriff Court. The Sheriff Court. The Court of Session can be accessed for a virtual tour on the Scots Courts website. If you want to make use of that, just write that down. Oh dear, having a bit of technical trouble. Can you all hear me at the back of the microphones? the law? Yep. Is that yes? Yes or no? Nodding. Right.
I've got heavyweight authority. Whenever you want.
Scotland's Supreme Civil Court is the Court of Session located in Edinburgh, where I began my underage drinking against the law, with jurisdiction over the whole of Scotland. The whole of Scotland. It's composed of a maximum of 34 judges, senators of the College of Justice, or Lords of Council and Session, one of whom seconded as a part-time chairman of the Scottish Law Commission. Now, we'll move on swiftly to the Sheriff Court. We'll come back to the Court of Session many a time. Moving on to the Sheriff Court, this is divided into 6 sheriffdoms, if you like, sheriffdoms. The first being the sheriffdom that we exist in, Grampian, Highlands and Islands. Another being Tayside, Central and Fife, Lothian and Borders, Glasgow and Strathkelvin, South Strathclyde, Dumfries and Galloway, and finally North Strathclyde. Each sheriffdom, with the exception of Glasgow and Strathkelvin, is then further divided into Sheriff Court districts, varying in number from sheriffdom to sheriffdom. Thus, for example, the sheriffdom of Grampian, Highlands and Islands, which we reside in, is divided into 16 sheriffdoms. 16 sheriffdoms. Are you with me there? Are you still awake? That's good. Stay with me. Stay with me. Now these vary in number. As I said, 16 sheriffdoms, Grampian, Highlands and Islands, involving Aberdeen, here in Aberdeen, Banff, Peterhead, Stonehaven, Elgin, Wick, Inverness, Port William, Portree, Dingwall, Tyne, Durnot, Kirkwall, Lerwick, Lochmaddy and further north, Stornoway. Now, each Sheriff Court district has at least one full-time sheriff.
Come on, David, come on.
Apologise. It's my cold.
I'll pretend to be on my phone.
Excuse me. That's a mobile phone. What's that in your lap? Let me. What's this in your lap? It's a mobile telephones. Extremely rude. Not permitted.
Sorry, David.
In my lectures.
Sorry, David.
I think you should have a think about that before you bring that out in my lecture again. Now, onto the appointment of sheriffs. We have floating sheriffs. Floaters. They float around Scotland. Yes. We have part-time sheriffs, honorary sheriffs of high authority. And the sheriff principal, jurisdiction of sheriff court in civil matters. The sheriff's jurisdiction is very varied and mainly original. I should say that the jurisdiction is mainly original. Bear that in mind, please. Actions raised under ordinary cause procedure, summary cause procedure, or small claims procedure. Small claims. These are minor cases. minor. Not dealing with the likes of, difficult to deal with points of law and appalling crimes in the High Court. Murder, rape, murder and rape. Now, the Civil Courts Review began its work on the 2nd of April 2007 under the chairmanship of Lord Gill, with the following remit: to review the provision of civil justice by the courts in Scotland, including their structure, jurisdiction, procedures and working methods. Yes, are you with me? Good. Having particular regard to the cost of litigation to parties and to the public purse. The role of mediation, and other methods of dispute resolution in relation to court process. Furthermore, the development of modern methods of communication and case management. Lastly, the issue of specialisation of courts or procedures, including the relationship between civil and criminal courts, as we come back to again. Two things separate and distinct, civil and criminal. The House of Lords, as I mentioned earlier, strictly speaking, it has the Appellate Committee of the House of Lords. Appellate, dealing with appeals. Appellate jurisdiction is what it has. It was replaced in October 2009, as I mentioned, by the Supreme Court of the United Kingdom. Let's not confuse these. It's exclusively a court of appeal, hearing appeals from the inner house of the Court of Session. It's also England's ultimate civil as well as criminal court for appeals. But not hearing criminal cases for the first time. It's not got original jurisdiction. No. How did it become Scotland's top appeal court? The ultimate appeal court? You'll have to see, inter alia, the Treaty and Act of Union of 1706-207, which we'll take a look at now. Now, the Treaty and Act of Union, Article X1X states that the Court of Session or College of Justice do after the Union and notwithstanding thereof remain in all time coming within Scotland as it is now constituted by the laws of that kingdom. Of Scotland. And for the better administration of justice as shall be made by the Parliament of Great Britain, and that hereafter none shall be named by Her Majesty the Queen, Her Majesty, or her royal successors, royal family, to be ordinary lords, Lords Ordinary. Yep, you with me? Ordinary lords of session, but such who have served in the College of Justice as advocates, not solicitors, learned advocates in the Court of Session, or as principal clerks of session for the space of 5 years. Now, this is stating that the Court of Session, the Supreme Civil Court, to continue as before. Those wanting to enter as an ordinary lord or indeed an advocate or principal clerk, had to defend a thesis in Latin. In Latin. We'll now move on to briefly look at the new Supreme Court of the United Kingdom. Supreme Court, as of 2009. 2009! Why was the House of Lords to be replaced by the Supreme Court? To answer this, we must look at the Constitutional Reform Act 2005, whose long title provides an act to make provision for modifying the office of Lord Chancellor, and to make a provision relating to the functions of that office, to establish a Supreme Court of the United Kingdom, and to abolish the appellate jurisdiction of the House of Lords, that is, the ability to hear appeals. Now, to make provision about the jurisdiction of the Judicial Committee of the Privy Council, to make other provision about the judiciary, their appointment and discipline, etc., etc. An examination of this Act's provisions in respect of its composition and jurisdiction of the new United Kingdom Supreme Court. Its 12 judges are called the President, the Deputy President, and the Justices of the Supreme Court. These justices are learned judges. Alright, are you with me? Learned judges of high authority, such as Lord Denning. Some would in fact say that Denning's judgments, from them it can be taken that he's a bit of a maverick. Some people would call it Denning's Law. A type of law in itself. Now, I think we're possibly getting a bit tired. You're looking a bit peaky at the back. It's not a phone, is it? I certainly hope not. It's not a phone, is it? No. Right. I think the next lecture we will test our knowledge on Scotland's civil courts. Look at the English courts of civil jurisdiction. It's not directly relevant to the Scots Law LLP, but it is important to understand. The difference between the English and the Scots courts. Two similar yet separate and distinct legal systems. Separate and distinct. Scots and English. Now, I think we'll end up there. But I would say to you, I know when you're doing your essays, when citing authority, I won't be a minute. Stay with me. When citing authority, this pamphlet, essentially, is not an authoritative source. Pamphlet. No authority. This book, which you can purchase for around £35, might be worth it. Has some authority. It's got to be said for it. Some authority. However, it's really when you get into the real deep stuff here, reading through all the judgments, don't read the rubric when you're looking at a case. Don't look at the rubric. Very useful summary. Not written by a lawyer. not written by a learned judge, as the judgments obviously are. Just Denning or Diplock or whoever you may be looking at. This is the real authority. The real heavyweight authority that you should be using. Not that many of you will. Not that many of you will sit and read that. Alright, I think we'll end that there. Thank you for coming. I would say to you also to make sure that you do attend the tutorials. Do attend them. You will lose your space on this course if you continue, as many of you have, to refrain from attending all of your tutorials. If you'd like to just head out at the back then.